Myth number 1, costs are irrecoverable. Technically not true. Civil procedural rules permit recovery of fixed costs. However, fixed costs are not much, and some judges are reluctant to award more than the Small Claims Track fixed costs. Judges will consider costs in the following situations, however. Number 1, business-to-business matters. Late Payment of Commercial Debts Interest Act 1998 allows for debt collection costs, the difference between late payment compensation as prescribed by the Act and the cost of the action. When claiming debt collection costs, it is advised you plead the same in the particulars of claim. Please note, even if a judge allows costs in these situations, they will assess the same. The more proportionate the costs, the more likely a judge will award the costs claimed. Number 2, business-consumer matters. Costs as per your terms and conditions, as agreed by the consumer. Admittedly, judges are more likely to award costs in business-to-business matters than they would business-to-consumer, because they may consider, depending on the wording of your terms and conditions, contractual cost clauses to be unfair. For this reason, it is advised you also claim contractual interest that is not onerous to help offset your costs. When claiming contractual costs and or interest, it is advised you plead the same in your particulars of claim. As with business-to-business matters, the more proportionate the costs, the more likely a judge will award costs claimed. The third and final situation where costs will be considered by a judge on a small claims matter, unreasonable behaviour. By virtue of Civil Procedure Rule 27.14 subsection G, such costs as the court may assess by summary procedure and order to be paid by a party who has behaved unreasonably. Indeed, in one case, our client was granted costs because the defendant did not produce a witness statement as ordered by the court. Other examples would include a defence and or counterclaim that has no legal basis and or is vexatious, failure to follow pre-action protocol as prescribed by the Civil Procedure Rules is another example of what may be considered as unreasonable behaviour. Please note, however, due to the judge's discretion, what one judge considers unreasonable behaviour may not be so by another judge, which is why it is very difficult to gauge. But nevertheless, we encourage that you request cost for unreasonable behaviour at a small claims hearing where you feel you are entitled to it.